It's clear to me that this case is going to be tough for the city of Chicago, but it's crucial, I think, for people to realize that the court, in its questions, seems to endorse the idea from Heller that reasonable restrictions are allowed. Justice Scalia made it very clear in his questioning that beyond the core finding in Heller that someone's entitled to a gun in their home for self-defense, that perhaps beyond that minimum it's up to legislatures, elected officials to make the decisions. That's the crucial thing here, because with 30,000 people killed every year in this country with guns, 80,000 people injured every year in this country with guns, elected officials need to have some choices that they can make to reduce crime and violence in their communities.
And I think the court was obviously very focused on the due process clause, and I think we feel very good that the court's focus on the due process clause is a good sign that the Second Amendment will be extended to the states. I think there's a very strong argument, the argument we just made to the court, that there's really no reason to distinguish between the Second Amendment and the First Amendment and the Fourth Amendment. All of those other critical substantive guarantees of the Bill of Rights have been extended to the states, and it really wouldn't make any sense and would in fact make the court's jurisprudence in incorporation fairly unstable if somehow the Second Amendment were singled out for not being applicable to the states. So we think, in a sense, there's a relatively straightforward path for the court here. It's in the due process clause, and the result would be to extend the Second Amendment across the country so it doesn't just protect people in the district or in the national parks, but it protects everybody across the country.